and crimes against humanity. And this is something that we are exploring, and I think that other countries in South Asia would also explore in terms of addressing the state of impunity that we suffer in the region. So this case has actually changed the discourse in Nepal, because this is first time that the perpetrators have felt that there is a personal consequence to the crime that they commit or the acts that they commit. Otherwise, the state of impunity is such that they would not really feel any sense of accountability, and they feel they are always above the law. And that is the case, because we have not been able, despite all those cases, litigations that we have brought in the Supreme Court, rulings of the Supreme Court, not even a single, I would say, a person has been prosecuted for their involvement in serious human rights violations in the country. So lawyers are actually engaged not only nationally but also internationally as well in terms of ensuring access to justice for victims of human rights violations in Nepal. We also face some dilemmas and challenges in this discourse, in this process of ensuring justice for the victims. As it was discussed in the morning as well, this notion of transitional justice and criminal justice. Transitional justice versus criminal justice. Though legally, it is very clear that transitional justice mechanisms do not supersede criminal justice mechanism or replace criminal justice mechanism. This is something that our own Supreme Court also keeps saying repeatedly, and this is what international human rights bodies have kept saying repeatedly. But this is what has been actually used or argued again and again. So transitional justice mechanisms such as Truth and Reconciliation Commission or Commission of Inquiries and Disappearances are the appropriate mechanisms to deal with the cases of crimes that committed during the conflict, is something that the state keeps arguing. And use as excuse not to investigate or prosecute in any of those cases of conflict era, for example. We also face this dilemma of peace versus justice. A lot of people argue that demanding justice in a way of prosecution would jeopardize the peace process, would jeopardize the newly established democracy in the country. Though we believe that peace without justice has no meaning, and justice would strengthen the peace, but of course this notion also keeps affecting our quest for justice and our struggle for justice in Nepal. Again, jurisdiction of military court, principle of double jeopardy, immunity also keeps coming up and affects the victims' access to justice. And these are also the issues that legal community in Nepal are also grappling with. There are also arguments that there are exceptions to the political offenses, political crimes. So those crimes committed in a political context cannot be prosecuted, or has to be dealt with different other mechanisms, or has to be dealt politically. This is what has also been argued repeatedly. And there have been a number of occasions where government has made the decision to withdraw the cases, criminal cases, against the perpetrators, stating that these are the politically motivated crimes or these are the political crimes. Of course, crimes are crimes. No matter who commits these crimes, politicians committing crimes doesn't make any crimes political crimes. But still, these are the issues that one has to grapple with when litigating every day in the context like Nepal. We also face difficulties in terms of statutory limitations in some of these crimes. For example, in the case of rape, sexual abuse that happened during conflict, we attempted to bring FIR, open the scope of the criminal justice system to the victims who suffer sexual violence during the conflict. The FIR was rejected on the ground that the FIR came very late. the statutory limitation that we have in the crimes of rape in Nepal is 35 days. Though it was already challenged in the Supreme Court by filing public interest litigation, the court has said that law has to be amended to expand this limitation because this restricts victims' access to justice. As the law has not been enacted as of today, victims of sexual violence continue to deny justice on the ground of this statutory limitation that exists. Similarly, in the case of murder, on the case of torture, we continue to face this problem. We also have to deal with this issue of retroactive effect of criminal law. In some of the issues of torture, for example, or extrajudicial killings, or some of the atrocities that happened in the past, where our existing criminal law or the law that existed at that time wouldn't define them as crimes. So can you prosecute those crimes enacting laws now? Is something that we have. Of course, international law is very clear on serious human rights violations. There is no problem of statutory limitation. There is no such thing as exist. Or state has obligations to enact legislations with having retrospective effect and prosecute those crimes. But at the national level, this remains a challenge. How you do it? So, as I said, I will be very brief. I just wanted to draw your attention to one of the interventions that lawyers are making in the country in terms of prevention of torture in Nepal. And I'm very proud to share these experiences to young lawyers in particular, presented here today, because there are so many different ways how we can use law in terms of preventing atrocities to happen, and in terms of advancing the understanding of the community on law as such. Torture in Nepal is a major problem. It was a problem even before the conflict. It was a problem during the conflict. It remains a problem even today. I'm sure many countries in the region have the same problem. Torture is one of the tools in criminal investigations. This is how we use torture in everyday, functioning of criminal justice system. We monitor police detention centers. We go there to provide legal aid to the detainees. Of course, no one would allow us to go to detention centers, NGO activist, lawyer, where do you have law that forces police to allow you to visit their detention center, for example. That used to be the question in the beginning. But using the constitutional provisions that we have in Nepal, for example, we have provisions in Indian constitution, or even before that, we have the provisions in the constitution that detainees have access to lawyers. As we don't have legal aid system that ensures that detainees actually have access to lawyers, we visit police detention centers proactively to provide that support to detainees. And we use this as an argument against the police that either you ensure access of these detainees to lawyers, or you allow us to visit detention centers. So as they are not able to ensure every detainees in their detention center have access to lawyers, they are forced to allow us to visit detention centers. So we visit detention centers, and we actually look into number of indicators. The rights that are there in the constitutions as the right of the detainees, whether those rights are observed in everyday functioning of the police or not. So we look into number of indicators, such as detainees have to be brought before the court within 24 hours of the arrest. If the person is detained illegally, the person is vulnerable to torture and other ill treatment in detention centers. So the reason why we are monitoring whether the person is brought to the court within 24 hours or not is to really see whether this is under observations, or whether that person is vulnerable, and how that has been improved, or how that can be improved. So when we visit, we see whether detainees are taken to the court within 24 hours. When we started the monitoring back in 2001, more than 70% detainees would say that they were not taken to the court within 24 hours, though this is the constitutional mandate. So every single person arrested, detained in detention, supposed to be brought to the court within 24 hours. This is the constitutional mandate, and police are there to uphold the constitutional law. But every day they violate the law. Every day they violate the constitution. So through the documentations, we actually expose, how the institution that is there to uphold the constitution and law violates law every day. So just monitoring, just visiting and questioning these sort of things, or bringing writs of habeas corpus when you find the case of illegal detention, you could actually have big impact the way police behaves to the detainees in detention centers. So when we were monitoring detention centers, more than 70% would say that they were not taken to the court. So we have been monitoring this for the last 10 years. So that figure really goes really down now. Similarly, we also look into the compliance of the medical check, because law requires every detainee to go through the medical check, and the copy of that has to be sent to the district court. When we started monitoring, more than 94, more than 8 and 90, or in that ratio, detainees would say that they were not taken to the hospital, or their medical checks were not done. So. Questioning it every day, being present, being there in detention every day, questioning this every day for many years would actually help to observe these kind of provisions that we have in the law, and prevents torture and illegal detention to happen in detention centers. So it actually grows quite high. The graph goes quite high now. For example, 94% detainees now would say that they are taken to the hospital for their medical check. Initially, it was very tedious kind of job. How long do you really monitor these detention centers? But if you really consistently monitor police detention centers and intervene at different levels, lawyers could actually make a huge difference. And this is the effort of lawyers in Nepal, and this is what I really wanted to share. I would stop here. If you have any questions, I'm very happy to respond to that. Thank you very much.